Now let's go to so-called Bybee Memo. I think one of the greatest stains on the history of this country is a memo dated August 1st, 2002, signed by then Assistant Attorney General J. Bybee. It concluded that the President has authority as Commander-in-Chief to override domestic and international laws prohibiting torture, to immunize anybody who commits torture, immunize them from prosecution. And many of us voted against Alberto Gonzalez's nomination for Attorney General because he refused to disavow legal conclusions in a memo that did not rule out the use of cruel, inhuman, degrading treatment of detainees during interrogations. Turns out that our concerns are well-founded. The New York Times recently reported that soon after Attorney General Gonzalez took over, the Department of Justice secretly endorsed combinations of the harshest interrogation tactics as legal, even though they'd been publicly withdrawn under the so-called Bybee Memo. Now, do you believe, so we know where you might stand on this, do you believe that the President has the authority under any circumstances to exercise a so-called Commander-in-Chief override and immunize acts of torture, as the Bybee Memo argued?
We are parties to a treaty that outlaws torture. Torture is unlawful under the laws of this country. The President has said that in an executive order. But beyond all of those legal restrictions, we don't torture not simply because it's against this or that law or against this or that treaty. It is not what this country is about. It is not what this country stands for. It's antithetical to everything this country stands for. Soldiers of this country liberated concentration camps toward the end of World War II and at the end of World War II and photographed what they saw there as a record of what the barbarism that we oppose. We didn't do that so that we could then duplicate it ourselves. The Bybee Memo, to paraphrase a French diplomat, was worse than a sin. It was a mistake. It was unnecessary. It, as I've read, I've read the memo and I've read some of what's been written about it. It purported to justify measures based on broad grants of authority that were unnecessary. The analysis in that memo was found to be defective, and the memo was withdrawn in favor of a later memo that narrowed substantially the basis for authorizing measures beyond, perhaps different from, those that may be contained in the Army Field Manual.
Would you, would it be a safe characterization of what you've just said that you repudiate this memo as not only being contrary to law, but also contrary to the values America stands for?
I do.
Okay. And is there such a thing as a Commander-in-Chief override that would allow the immunization of acts of torture that violate the law?
Not that I'm aware of.
Thank you. The first of these memos was issued over the objections of Deputy Attorney General James Comey, who predicted that Department of Justice would be ashamed when the public learned of them, and of course the public did learn of them. It would appear, though, that they still remain in effect as governmental policy. Will you ensure that the Department of Justice will rewrite its guidance on interrogation and degrading treatment and bring it back into line with the law that Congress passed?
I'm certainly going to examine the underlying memos and the underlying facts. I have not been read in on, I think is the Washington expression, any classified program or information, including the classified information that relates to interrogation methods or the memoranda that relate to interrogation methods. And so I can't, as I say, that there's something that's out of line with the law in those programs until I see the programs and see the memos and see whether they are in alignment or not.
Will you not only read the memos, but make sure that they are in line with the testimony you've already given and your own views of what is allowed under our law?
I certainly will.